SABC News senior reporter Canny Maphanga, Wits School of Governance lecturer Dr. Thelela Ngcetane-Vika, alongside UKZN international law lecturer Christopher Gevers, join us in studio to unpack and on Zoom. Canny, you are in studio. A very good evening to you. I'm going to say hi to the rest of my panelists in a short moment. But Canny, since you're here, you saw the rebuttal and defense of the Israelis. Basically, even now, the common sense that we're getting is that basically South Africa has no case in jurisprudence or otherwise. They are just clutching at straws. What do you say to this?
Well, good evening to you, Alicia, and to the viewers at home. I'm sure this is a perfect opportunity to give you a wrap of day 2 of today's proceedings. Today saw the conclusion of South Africa's bid for an urgent intervention into the situation in Gaza from the World Court. Following South Africa's compelling submissions addressing the direct atrocities in Gaza since October 7 to date, the world finally heard the state of Israel's response to South Africa's claim of acts of genocide. The hearing kicked off with Israel accusing South Africa of weaponizing terms, specifically the term genocide, and ignoring the events of October 7 in their application before the court. Let's take a listen.
The attempt to weaponize the term genocide against Israel in the present context does more than tell the court a grossly distorted story. And it does more than empty the word of its unique force and special meaning. It subverts the object and purpose of the convention itself, with ramifications for all states seeking to defend themselves against those who demonstrate total disdain for life and for the law.
All right, well, let's also welcome our panelists there. Let's get some word from Wits School of Governance lecturer Dr. Vika. Doctor, a very good evening to you. Thank you so much for joining us. Well, look, I suppose the Israeli defense centered on the fact that basically there should have been first a dispute with Israel in terms of communication. Talk to us about that.
Good evening, and all your viewers. I've got a bit of flu, so you will pardon my voice. Well, there are a few things. The first one, on the declaration of dispute, there are a number of things that may be in dispute. Well, the South African government, through the DECO, asserts that they followed all the processes, the diplomatic processes. The exchanges between the two states, we may not be private to all, but I'm sure as the time progresses and we will stay through those, so one can have a limited view on that. But perhaps we'll talk about the key issues that this case hinges on. And the grounds and the definition of genocide, whether the thresholds have been met in terms of international law and the intent, and whether, in my view, what was the strength of both legal cases. Thank you.
Thank you so much. We're going to have a word from Christopher Gevers, who's from the UKZN international law lecturer. But Canny, since you're still here in studio with us, I mean, I understand, as we started this discussion, the rebuttal of Israel focused on these certain points, that South Africa does not have a case specifically around the word genocide. Please elaborate there.
Yes, this includes part of our presentation that we were presenting earlier regarding today's proceedings. Just to continue quickly with that, Becker further rejected the claim of genocide, calling it inconceivable, adding that Israel has a right to defend itself within the bounds of international law. He further suggested that South Africa may be in breach of its obligations under international law, and submitted that South Africa, quote-unquote, enjoys close relations with Hamas, the organization that carried out the October 7 attacks. Let's take a listen.
These relations have continued unabated even after the October 7th atrocities. South Africa has long hosted and celebrated its ties with Hamas figures, including a senior Hamas delegation that incredibly visited the country for a, quote, solidarity gathering just weeks after the massacre. In justifying instituting proceedings, South Africa makes much of its obligations under the Genocide Convention. It seems fitting then that it be instructed to comply with those obligations itself.
So in summary, counsel on behalf of the State of Israel in its defense told the court that South Africa has not been able to prove intent to commit genocide, as stated in the convention. The state also argued that there was no dispute before the ICJ and the risk of irreparable harm that warrants the indication of the provisionary measures sought does not exist and would in turn prejudice Israel as it would render them defenseless. On the question of jurisdiction, counsel argued that there was no evidence of a dispute between the states and that this is a unispute, a one-sided clapping of hands. Let's take a listen to Shaw.
Here South Africa cites only a couple of general public statements by Israel, referencing merely a press report by Reuters and a publicity release from the Israeli Ministry of Foreign Affairs. These responses were not addressed directly or even indirectly to South Africa. There is no evidence of positive opposition as required by the court. Further, South Africa cites no relevant exchange between the parties, which would be the normal fashion for the expression and determination of a dispute between states.
And finally, the state accused South Africa of painting a flawed picture that is void of any reference to Hamas.
The applicant paints a dire picture, but it is a partial and deeply flawed picture. The application is so distorted in its descriptions that it prevents the court from properly assessing the plausibility of the rights asserted by South Africa. Plausibility cannot be determined based on the unsubstantiated allegations of one party to the proceedings alone, if Article 41 of the court statute is to have any meaning.
So to conclude, Alicia, Israel is of the view that the provisionary measures sought should be rejected by the World Court, as it will prejudice Israel and in effect strip it of its right to defend itself.
Very interesting indeed. Let's now rope in, as promised, as part of our panelist, UKZN international law lecturer there, Christopher Gevers. Christopher, your assertions about what you saw in terms of the Israeli defense today, what did you make of it?
Thanks so much for having me. So I think what we saw was a redirection of focus onto Hamas. And I think there were both political and legal reasons for that. So the political reasons, I think, were to try and reorient the narrative, right? To suggest that there are good states in the world and there's bad states in the world, or there's civilized states and there's barbarians. And in fact, Israel is one of the good guys, and we should give it a measure of good faith assumption. And I think also the suggestion that South Africa is somehow acting on behalf of Hamas was part of that same narrative, and I think it should be rejected with the contempt it deserves. I think the legal reason for saying that this is a question of focusing on Hamas is threefold. So the first is that there was an attempt to say that the genocidal acts that were set out in detail by the legal team were in fact the fault of Hamas. So the killing, the bombing, the targeting of hospitals, the humanitarian crisis, and so on and so forth, was in fact caused by Hamas, and Israel had done everything it could to prevent that as genocidal acts. And I think the facts speak for themselves, and I think the references to the various statements by the UN are fairly difficult to overturn on that factual basis. I think more specifically, the focus on Hamas was to say we need to address the question of genocidal intent by saying that the intention here was not genocide but self-defense. I think this was the attempted shift of the legal narrative. And I think the problem here is Israel has two problems, in fact. The first problem is that there is a debate about whether or not self-defense can be applied in this instance, because Israel is in power. And I think the jurisprudence of the court on this would be a hill that Israel will have to climb, and they started that today. I think secondly, and more difficultly, is that self-defense is not a defense to genocide. So even if there's a right to self-defense, the way that that right is pursued is subject to international law, and that includes the prohibition on genocide. And I didn't see a lot of effort, despite what your earlier guest mentioned, I didn't see a lot of effort to really tackle the question of genocidal intent. What I did see, and I think this is telling, is an effort in the second half of the presentation to start to try and undercut the possible provisional measures order. So one way to think about this is that Israel accepts there will be some version of provisional measures, but it wants to make sure that at least the first one, the most difficult one, perhaps we might call the nuclear option, which is a ceasefire ordered by the court, is made difficult for the court to give. And on that basis, they made a case that to essentially to order a ceasefire would be to hamstring Israel on its right of self-defense without at the same time constraining Hamas from undertaking attacks. And I think they won some small victories on the part of the court, because it will be difficult for the court to give an order that only targets one side. So I think that's really, reading between the lines, the most legally substantive submissions were actually about the provisional measures. The first half was largely rhetorical about alternative facts and so on and so forth. But a lot of time was spent trying to say, you can't go so far. This is too far provisional measure, which in a sense might be a concession from Israel that they think there will be some order from the court, and they're trying to water down its effects.
All right. And with you, Canny, I know there was a discussion even prior to the dispute between South Africa and Israel that should have emanated before South Africa actually took the case to the ICJ. Please elaborate further on that, because it's quite confusing as to who's telling the right story and who's being truthful.
Well, the state of Israel is telling the court that there wasn't a dispute required for the ICJ to intervene on at this stage, and they are disputing that these public statements, or the fury that we saw in the past few weeks following the October 7 attacks, actually was a direct engagement with the state of Israel. They're saying that they weren't given the opportunity to respond in time, and that in actual fact that a dispute was not established by the South African government, and therefore the court does not have a jurisdiction. However, the South African government doesn't agree with this, saying that how else could you view some of these public statements and efforts by the government over the past 13 weeks to achieve justice for Palestinians in Gaza. So I think that is where there'll be confusion, and the World Court will have to make a determination there if a dispute was in fact established prior to going to the next step, which is the final step of heading to this World Court to say that we're now establishing litigation and we need you to intervene to save lives.
So basically they're saying there was no a prior point of contact, or it was rebuffed in that regard?
Well, they acknowledged that there was contact or direct engagement made with the Israeli government, but their version is that when they attempted to respond or were intending to engage with the South African government, the application had already been pursued. So they weren't given a chance to respond, and it was a one-sided dispute. That is basically what they tried to tell the court today.